Dzień dobry Państwu. Witam wszystkich na drugim spotkaniu z cyklu Środowisko Prawne 2020, organizowanym przez Zespół Badawczy do Spraw Prawa, Ochrony Środowiska i Bioróżnorodności na Wydziale Prawa i Administracji Uniwersytetu Warszawskiego. Czy mnie słychać?
Słychać.
Super, bardzo dziękuję. Ponieważ dzisiejsze spotkanie odbywa się w języku angielskim, pozwolę sobie dokonać krótkiego wprowadzenia i przedstawić naszego gościa właśnie w tym języku. Dobrze, no w takim razie zaczynam. Welcome everyone to the second meeting of the Legal Environment 2020 project organized by the research team for the environmental and biodiversity law, which is of course a part of the faculty and administration, faculty of law and administration at the Warsaw University. Let me start by reminding everyone that the project comprises of a cycle of meetings with practitioners and academics specializing in humanities, as well as social and empirical sciences. The idea behind the project is the social ecology, meaning the organization of the society and the environment are interconnected and influence each other. We simply cannot achieve a good society without a proper environmental policy and a healthy habitat, and vice versa, right? There is no future for the nature unless we take care of our democracy and its laws. Now it is my distinct pleasure to introduce our today's guest, Dr. Visa Kurki, a Finnish legal scholar and a philosopher, a fellow at the law faculty of the University of Helsinki. Dr. Kurki received his PhD from Cambridge, and his dissertation on legal personhood has not only received some awards, but also stirred an academic debate. Moreover, Dr. Kurki's academic interests concern animal rights also, and this is why we kindly asked him to give a lecture on the idea of legal personhood of animals as a mean of securing their rights. Please stay with us after the lecture, as there will be time for questions, comments, and hopefully some interesting discussion. Just for your information, the meeting is being recorded. Alas, without further ado, Dr. Kurki, please start.
Right. Thanks so much for the invitation. It's very lovely to be here virtually in Poland. I must say that my life is currently quite, has a lot to do with Poland right now, because I'm giving this presentation today. Then actually next week, I'm also speaking at a Polish seminar, and in between a certain Polish computer game is going to be published that I think is going to be important for the upcoming weekend, definitely. So very nice to be here. Thanks for the invitation. And by the way, this is my cat Shiva, who will probably be bothering me for the most of the presentation. So, as noted in the presentation, the introduction, this talk is about legal personhood and animal rights. And since I understood that there's going to be both lawyers and non-lawyers and law students and students of other fields in the audience, so I've tried to make it interesting for both. But feel free to interrupt me by asking questions in the chat, and maybe Cesare can then notify me if something is very unclear. I'm using unclear terminology or something like that. Right. So this is the book that Cesare mentioned, and So I should especially mention that it's now become open access as of last August. So this means that anyone can freely download it from the website of Oxford University Press. So if you're interested in this topic, feel free to go ahead and download it as a PDF. But the book presents an overall theory of legal personhood. So like these important cases regarding legal personhood include, well, animals, which is what I'll be focusing on today, but also, for instance, the historical case of slaves, which are usually understood as having been legal non-persons. Then the difficult case of fetuses, whether they are legal persons or non-persons, or maybe something in between, whether historically women have been persons or non-persons. Well, corporations are legal persons today and have been since ancient Rome. And well, more topical cases include rivers and whether AIs could become legal persons. So here are some examples of how legal personhood and animal rights are connected in today's public discussion. So the most central way, or the way that has received most like public attention, has had to do with so-called habeas corpus trials in certain countries, most centrally the United States and some Latin American states. So habeas corpus is basically means the fundamental right to freedom, of being free from a restraint. And what started as a project in the United States, this organization called the Non-Human Rights Project started arguing in courtrooms that, for instance, chimpanzees and some other animals such as elephants are persons. They are such developed and autonomous beings that they have the right to bodily liberty. So this development that started in the United States has since moved or spread around the world, and has actually had its most important victory in Argentina, where an Argentinian judge ordered a particular chimpanzee, Cecilia, to be released from zoo. And what's interesting is that this is not based on statutory law, so it's not based on like acts of parliament or anything like that, but rather the courts have here been using case law and the idea of that chimpanzees have fundamental rights. But legal personhood has recently become a prominent topic, as already mentioned in other areas as well. So for instance, in New Zealand, the Whanganui River, which is a holy river for the Aboriginal Maori people, has become a legal person. So this means that it's a bit like you could think of it as like a foundation or a non-profit corporation that's taking care of the river and representing its interests, so to say. And similarly, well, many lawyers have recently become interested in the topic of whether robots or AIs could be legal persons. Whether, for instance, a trader that buys and sells stock could be a robot that could go bankrupt if it does not do too well. Another example is, for instance, autonomous cars. Whether autonomous cars, if they break or in some ways say cause harm to other cars, for instance, other drivers or whatever, whether the car itself could be held liable for the damage. The difficult issue here has to do with the fact that it's hard to pinpoint who exactly is the faulty party. So is it, for instance, the owner of the car or the passenger or the programmer or so on? So one solution that has been proposed would be that the car itself would be understood as a legal person that could own its own property, for instance. But anyway, I'll be focusing on animals here. So what I was hoping to do, and I hope this works, is to show to show a video shortly on the work of the Non-Human Rights Project, and this will sort of act as an introduction to these questions. So what is legal personhood, and how does legal personhood relate to animal rights? And the way I approach this issue in my book, for instance, is to first articulate what I call the orthodox view of legal personhood, which is the prevalent view of legal personhood that I imagine that probably Polish law students are also taught when they study law, especially private law. And then I'll offer my own theory of how, in what ways I disagree with the orthodox view. But I was hoping to show you a video that will hopefully be a somewhat more a stimulating way of presenting the orthodox view. So now I'm just going to have to share my computer sound instead of.
These animals are extraordinarily cognitively complex. So when you imprison a chimpanzee, the chimpanzee understands that tomorrow he's going to be imprisoned. And as far as he knows, it's not going to end. What we're trying to do is change the way people view non-human animals. Because right now, it's, are you a human? You have rights. You're not a human, you don't. And we're saying that's wrong.
Now to a bizarre lawsuit with big implications, and the key question is whether a chimp is a person.
Tommy is a legal thing right now and has a right to get out of being held for his entire life in a cage.
When I began, people laughed at me and they barked when I went into a courtroom.
They are not human beings, and putting them on the same legal standing as a human being, that's insanity.
So we may be coming to you to help us in filing an affidavit, talking about the cognitive abilities that would persuade courts.
Question. Visitors have balls.
Oh my God. Merlin died last night.
Captivity, it's just killing these guys. So we need to locate every surviving chimpanzee in New York State and file a suit on their behalf. Someone told me you had a monkey.
There's a chimp in there. He's got TV to watch. Yeah, he won't do much. He just sits there.
May it please the court. Tommy is indeed a person who is entitled.
You assert he's a person. We haven't decided that.
All we can do is kick the first door open.
Mr. Weiss, you want to come to our court and ask for a right that's never been granted in the history of humankind.
It's a hell of a war. There's going to be a lot of battles in the war. But it's time to begin.
Right. I hope you could hear the sound, because I actually couldn't hear anything, but it might have to do with the difficulty of sharing audio via Zoom. But Cesare says that he could hear the sound, so that's very good. So this trailer is for a documentary called Unlocking the Cage, which follows the Non-Human Rights Project in the United States, and I do recommend watching it if you're interested in this topic, because it's a relatively lively way of getting familiarized with these debates. But even though I have much respect for the Non-Human Rights Project, I'm actually going to be somewhat critical of their sort of the way they conceptualize legal personhood. Because I think they rely on this what I call the orthodox way of conceptualizing legal personhood, and the orthodox view is very black and white. It's very bifurcated in this meaning that it views everything as having like two opposite poles and nothing else. So you can think of it in terms of an inventory of the universe, meaning what there is in the universe. So according to the Orthodox view, there's just two categories. So this is how, for instance, this originates from 19th century German legal scholarship, more or less. So and actually from the philosophies of Immanuel Kant and Georg Wilhelm Friedrich Hegel. So the idea is that there are persons who are ends in themselves, who have moral value. There are two categories of persons. So natural persons are human beings, and then there are artificial persons that are corporations. And everything else is things. And things are, well, things that can be owned, for instance, the property. So from this point of view, obviously, animals would probably fall under things, right? But it's actually not that simple. But before we go to that, I'm going to show you a couple more of the bifurcations of the Orthodox view. So often, especially in continental countries, in civil law countries, so not English-speaking countries, I'm talking about Europe here, you often also talk about subjects of law as synonyms for legal persons. I think it's podmiot prawa in Polish, whereas legal things are equated with objects of law. I'm not sure what that is in Polish, though. And the idea is that only these persons or subjects can hold rights, and their rights pertain to things. So human beings, corporations, organizations, and so on, they hold rights, and these rights pertain to, for instance, mobile phones and slaves and animals and bananas and so on. And these things have no rights at all. They're only the objects of rights. But we are, of course, we do protect animals, but according to the Orthodox view, the animals still don't have rights, and I'm going to explain that in a bit. But this is how the Orthodox view of legal personhood can be summarized. So there are natural and artificial persons, so subjects of law, and there are things and objects of law. And only persons, according to this bifurcation, can have rights and or duties. And because animals are things, meaning that animals can be owned, they can't hold any rights at all. And well, we do protect animals through animal welfare legislation. So there are animal welfare acts in Finland and in Poland and in more or less every Western country at least. But this only results in duties for people, but no rights for animals at all. This is how it's traditionally understood. And also in animal rights scholarship, there is this strict bifurcation between animal welfare or welfarism and animal rights. So according to this traditional bifurcation, there's only these two alternatives, more or less. So according to welfarism, we should treat animals well, but we can exploit them. So we can own animals, we can kill animals, we can eat animals, and so on, as long as we treat them humanely and well, and we're not cruel toward them. And this is usually expressed as the prohibition of unnecessary suffering. So animals should not be inflicted with unnecessary suffering. And traditionally, it's understood that animal welfare results in no rights for animals. And on the other hand, the other alternative would then be animal rights. And this is understood as something very radical. So animals would have strong fundamental rights. Animals would no longer be things at all. So you could not own animals anymore. You couldn't exploit animals. You couldn't eat meat. And animals would definitely be legal persons. So this is the traditional view, very black and white in a sense. And according to this traditional view, if we think of like questions of animal ethics and animal rights, the only meaningful question is, should animals have legal rights? But I in fact want to suggest and argue for a somewhat different understanding, a somewhat different framing of the question, which is that animals in fact already have some legal rights. It's perfectly meaningful to say that animals already have some rights, or the right against being subjected to cruelty, for instance. But the question is, what further rights should they be given, if any? So it's not black and white at all. In fact, you can have a very limited set of rights, or you can have very extensive and sort of strong rights, so to say, as human beings do, for instance. So and there's a lot of gray areas in between, and that's what I'll be arguing for in what follows. So the universe, the inventory of the universe that I would be that I would prefer, rather than the one I presented earlier, would be one with more shades of gray, so to say. Well, these are not shades of gray here, but rather shades of blue and shades of yellow. But anyway, so there are, like, so to say, full legal persons, but then there are some entities that maybe have some rights relating to legal personhood. For instance, fetuses could be such an example. And then there would be like full things, but also entities that are to some extent things, but not completely, for instance. And animals could be somewhere in between here. So, so in my book, I've then actually argued for what I call a bundle theory of legal personhood, and I'm not going to go through it here. But what I think legal personhood has to do with, instead of the sort of black and white question, that something is a legal person if it has any rights at all. I'm suggesting that it's a bundle, so it consists of many different things, and they don't always go together. So to say, full legal persons, such as adult human beings of sound mind, have all of these rights. I call them incidents here, but you can think of them as rights and duties. So they have all of these rights. So they can, for instance, own property, their body and life and personal integrity are protected, and they can be victims of crimes and so on. It consists of all sorts of elements. But then you can also have beings that don't have all of these rights, but have a more limited set of rights. So for instance, fetuses, again, would be an example that actually fetuses have some limited rights even before they're born, and then after they're born, they receive a full set of rights. And what I think how it would work with animals is that currently animals have very limited rights, but if animals were to become more closer to legal personhood, they would gain more of these rights. Most importantly, probably their body and life would be protected in a more sort of full-blown manner, and they would have legal standing. So legal standing means that they could appear in courtroom in their own name, but they would of course have a representative, a human being who would represent them, because animals could at most be what I call passive legal persons, meaning that they couldn't act on their own behalf. So only adult humans of sound mind can normally be active legal persons, meaning that they could act on their own behalf, and they could be held legally responsible. So it would not be very meaningful to hold animals legally responsible or let animals sign contracts, for instance. So that's not the part of legal personhood that most animal rights advocates are campaigning for either. So if we think of legal personhood on a continuum, it would be something like this, actually, that 200 years ago, we didn't have many animal welfare laws at all. So animals were completely legal non-persons. Today, we could maybe say that animals are maybe not legal persons, but they are subject of rights under certain laws. So for instance, under animal welfare law. And this is actually something that the Polish professor Tomasz Pierdzikowski has been suggesting as well, that we could distinguish personhood from being a subject. So an animal could be the subject of certain limited rights without being the kind of person that children and adults, so human beings in general, and corporations are. So instead of just having like two alternatives, animal rights or welfarism, there's actually a lot of different alternatives that have been offered in the literature among animal advocates and so on. So the most traditional example would be, or I mean, the approach that was taken before the advent of modern animal welfare laws was that animals are pure things. So they are like any other property. For instance, William Blackstone, who was a famous British or English lawyer in the 18th century, wrote that animals are just like any other property. So you can more or less do whatever you want with them. So this would be like the pure things approach. Welfarism, the protection of animals from unnecessary suffering and protecting their welfare, takes a small step toward more rights, more extensive protection of animals, and it focuses on welfare and prevention of suffering, as we can see here. Then in Switzerland, we can see something that I've called here the weak dignity approach, but I'm not going to go into that here. It just means that animals have a limited protection of their dignity in the Constitution. Then what the Non-Human Rights Project is arguing for is what I've called here strong dignity approach. So strong dignity approach means that the Non-Human Rights Project is arguing for dignity rights, what they call dignity rights for animals. And these would be very strong because the animals would, for instance, be freed from their cages and so on. They would be entitled to live freely, normally in well, some kind of a place sort of reserved for them, so not necessarily in the wild. Then I've actually been involved with the Finnish Animal Rights Law Society in drafting a suggested amendment for the Finnish constitution, which would involve incorporating or amending the Finnish constitution so it would include certain fundamental animal rights. And the proposal has been translated into English as well. I'm not going to go into that here either, but if some of you are interested, feel free to email me about it. And then what I earlier called the animal rights approach is actually better labeled as abolitionism. Abolitionism meant in the 18th and 19th century United States, the movement to abolish slavery. And that's what the sort of most radical animal rights activists are demanding as well, that we cease owning animals altogether, we cease exploiting them altogether, and this would probably be the strongest possible animal rights position, maybe. So there's actually a lot of different options, a lot of variety, much more than the simple bifurcation between welfare and rights. And in fact, you can argue that all of these result in rights, though some of them are just weaker rights than others. I'm going to talk briefly about the background of the orthodox view, just to give you an idea of why we have this very black and white idea of rights and legal personhood. I guess we could start from the Middle Ages just briefly. So as some of you may have heard, the Middle Ages didn't, people in the Middle Ages didn't think of the sort of dividing line between humans and animals in as strict terms as we do today, or as many people do today and have done since the dawn of the modern era. So some animals were actually prosecuted in courts, and this was serious business, meaning that they actually had their own lawyers, and there were actual trials and so on. But starting from the modern period, thinkers like René Descartes, for instance, the French philosopher, propounded philosophies that enacted this strict barrier between humans and animals. So humans were seen as rational beings with souls, and animals were seen as irrational automata, like machines in a way, that didn't have souls. But the way these things are conceptualized today have to do especially with the legal philosophy of 19th century Germany, and I guess 18th century as well. So two important things here are, first, the idea that rights have to do with choices. This is called the will theory of rights. So in order to have rights, you must be able to go to court and sue someone. You must be able to do it yourself. So actually not even children really had rights in the strict sense, because children couldn't go to court themselves, for instance. And animals obviously didn't have rights according to this idea of rights. And another issue had to do with this strict division between persons and things. So you were either a person or a thing, and only legal persons could hold rights. This had to do with this idea of legal capacity. So only legal persons had legal capacity, right? Capacity for rights and obligations. So the background, like the intellectual background of this, had to do with, well, it had its origins in Roman law, but also in the philosophies of Immanuel Kant and Georg Wilhelm Friedrich Hegel, as I mentioned earlier. So both presented their own will theories of rights, and for both, this idea between persons and things was very important. So those of you who have studied philosophy, for instance, have maybe heard of Immanuel Kant's idea that persons should never be treated merely as means, the categorical imperative, whereas things can be treated merely as means. And this idea was then incorporated in a way into law, especially by the great German legal thinker Friedrich Karl von Savigny, who applied these philosophies to law. But what's important to remember here is that both these philosophers and Savigny and most other legal scholars of the time were mainly interested in private law. So private law is the law that regulates especially relations between individuals or individuals and a corporation, for instance. So things like property and contracts and so on. But it could be contrasted with, for instance, criminal law and with public law, which have to do with how criminals are punished and how, for instance, what authority the state has with regard to individuals. So these thinkers were not very interested in public law or criminal law, at least with regard to these presentations. And this view then spread around the Western world, actually. So you can clearly see it in the German civil code. I haven't taken a look at the Polish civil code, but you can definitely see the German civil code. So you have a chapter for persons, you have a chapter for things, and animals are understood as things, even though they now have an interesting declaration that animals are not things, but are regardless treated as things. The great English legal philosopher John Austin imported this view to England after having studied in Germany. And actually this view still works quite well in private law. So when you think about property, contracts, and so on, this idea works quite well. So from the point of view of private law, we can think of animals as from more or less two lenses. So first, animals are chattels or things. Chattel means like movable property. So a property that can be moved around, as opposed to, say, houses that cannot be moved around. So if I have a pet dog, legally the dog is a legal thing. It's my property. So I can sell the dog, for instance, and if the owner discovers that the dog had some sickness that I hadn't mentioned, then the dog is faulty. There is a fault in the product, for instance. So that from that point of view, the dog is clearly a thing. Another thing or another issue relating to the property status of animals is that they're also dangerous beings. Animals can attack other people, for instance, and usually this is regulated in the way that owners must control the animals they own. But this explanation of private law, of property and so on, then spread to explain the whole of the law. So like the lenses that you could use to understand private law were used to understand the whole of the law. And what I've noticed happens very often is that these concepts such as legal person or subject of law and things and so on, they're presented in private law textbooks, but regardless as general ideas, general concepts of law. So here is a Finnish example. It's an example from a Finnish textbook. So in the right, there's the Finnish text, but I guess most of you won't be able to read that. But in the left, there's an English translation. So this is an introduction to commercial and property law. It says the one who, according to the legal system, has or can have rights is called a subject of law or a person. And they have a legal capacity. And legal capacity means that a person can be endowed with rights and duties. So even though they're talking in this private law context, what they're actually, the context has to do with contracts, with property, ownership, and so on. This is actually presented as a general idea. So what they're sort of implicitly saying is that because animals are not legal persons, they don't hold any rights at all. But what this sort of forgoes is the fact that we have had animal welfare laws. Some of them, some were already enacted in the 19th century. Much more laws were enacted in the 20th century. And this theory, this very black and white theory of legal personhood and rights was preserved, and there wasn't like attempts to accommodate these animal protection laws, but rather what happened was that scholars simply said that, well, we protect animals, but that only means that humans have the duty to protect animals, but regardless, animals don't have any rights because animals are not legal persons. But the thing is that the theory that was useful to explain these features of animals, that they are chattels and things and that they are dangerous beings, it's questionable whether it could be used to explain these new features of animals. For instance, that the law, well, first of all, many animals are not protected as members of some species, but that's not necessarily animal, that doesn't necessarily have to do with animal rights, it's just environmental law. But perhaps more importantly for our purposes here, animals have now also been recognized as sentient beings. For instance, in the Treaty on the Functioning of the European Union, it states explicitly that animals are sentient beings, as do some civil codes of certain European countries. And this traditional theory of legal personhood was not necessarily the best theory to explain this feature of animals, that they are also sentient beings that are protected from unnecessary suffering. And I would in fact argue that animals do hold rights today in virtue of animal welfare law. So we first of all, we protect animals more comprehensively than in the 19th century, but we also understand rights differently than we did in the 19th century. So as I already mentioned, in the 19th century, the most important theory of rights was the will theory of rights. So rights are protected choices. But that has since become challenged or complemented by the interest theory of rights, according to which rights are interests that are protected through duties. So if we, for instance, want to talk of children's rights to be nurtured, or their right to education or whatever, we're not thinking that the children should have the capacity to go to court themselves to demand these rights, but rather what we're thinking is we're protecting these children's interests. And similarly, children have the right not to be assaulted. You're not allowed to hit a child, for instance, and thereby the child has the right not to be hit. And so we could say the same thing about animals, actually, that animals have the right not to be subjected to certain forms of maltreatment. So we can't really say that the will theory has like a monopoly on how we understand rights anymore. So what's changed since the 19th century, when this theory of legal personhood, this traditional black and white understanding of legal personhood, was developed? Well, first of all, animals are not anymore only chattels and dangerous beings, but also protected sentient beings. And we don't understand rights anymore only as protected choices, but also as protected interests. So that's why I think it's already meaningful to say that animals already hold some legal rights, but animals are not legal persons in the same way as adult human beings or children or corporations are, but animals regardless hold some limited legal rights. So if we now go back to this bundle theory of legal personhood, what I was thinking I'd do is suggest that these different approaches to animal rights that have been proposed, the ones so on the scale. So what I hope to do now is suggest that what they're actually arguing for is just different kinds of rights, different incidents of legal personhood. And some of them sort of entail that the animals would come closer to legal personhood than others. So if we now start from the animals things approach, well, animals would be treated according to this approach like any other piece of property, and that would mean that animals wouldn't have any rights at all. Whereas with welfarism, animals would still be, or animals are still treated like property, but they have some limited rights against cruelty or unnecessary suffering. However, if we move further to the strong dignity approach of the Non-Human Rights Project, then it gets a bit different, because according to this approach, some animals would not really be treated like property at all anymore. So if an animal has the right to personal freedom, it's quite difficult to reconcile with the idea that someone would still own the animal. So what aspects of legal personhood the animal would gain here? Well, the animal would have the right to personal freedom. The animal would have legal standing to enforce this right. So legal standing means, as mentioned, the idea that you can be a party to a lawsuit. You can have a lawsuit in your name. So as it stands in most Western countries, animals cannot be parties to lawsuits. A lawyer cannot take an animal as their client. But if the animals had legal standing, then you could take animals as your client if you're a lawyer. And I think for those animals that are affected, this would result in legal personhood for these animals. According to this fundamental rights approach, on the other hand, animals would receive certain fundamental rights in the Constitution. They would also have the legal standing to enforce these rights. They would probably still be property, but property with relatively strong rights. So the idea would be to balance the property rights of human beings with the fundamental rights of animals and try to find the best possible compromise. So this would not be abolitionism, meaning that the property status of animals would not be abolished completely. And this would be such strong rights that we could talk about the legal personhood for animals. And if we go to the very extreme of abolitionism, this would mean that animals would stop being property altogether. They would gain fundamental rights, such as the strong right to life. So basically killing an animal would be something like a homicide or a murder or something like that. They would gain legal standing, so they could appear in courts. And this would also clearly result in legal personhood for animals. But the exact border, if we think that animals have no rights here and a lot of rights here, the exact border of when they would become legal persons is not clear at all. It's quite fuzzy, actually. So to conclude, I guess I've been talking for about 45 minutes, so that's probably enough. So legal personhood has traditionally been viewed as this either-or affair. So you either don't have any rights or you're a legal person and then you have rights. But my account is much more gradual. And that's why I think it's often actually more meaningful to talk about what rights animals should have rather than whether they should have rights at all. The traditional discussion has often been, it hasn't really progressed that far because people are simply debating whether animals should have rights at all. But if we actually accept that animals already have some limited rights, then we can, I think, make some progress. And there are all sorts of accounts and possibilities. So you can then discuss issues like, do animals only have so-called negative rights, or should they only have so-called negative rights? So basically the right to be left alone, or should they maybe also have positive rights, such as the right to receive assistance in certain cases if the animal is, for instance, sick or injured or something like that. So you can have all kinds of discussions once you get past the initial barrier of whether animals have rights at all. Right. So thank you, dziękuję. I look forward to the discussion. And feel free to email me if you have any questions.
Thank you, Visa, for this excellent lecture. I hope it's only an introduction to the problem we will explore further, especially those reasons why we should grant the animals their rights and what rights they should be, whether they should be based on the natural law or rather on the positive law theory. May I start with a question to you?
Yes, absolutely.
What would you say is the main reason why people accept legal personality of immaterial beings such as corporations or societies and other institutions, but not of real living creatures such as animals who are capable of emotions and suffering? Because, well, I am wondering why especially some conservatives thing against those trends in legal philosophy and modern philosophy as well, and refuse to even think about such personality of animals. It is not very revolutionary, right?
Yeah, that's a very good question. I guess as regards to legal person of corporations, I mean, that has very, very long traditions, right? It goes back to Roman law. So it's, in a way, if you start thinking about it, it's quite strange. It's a strange idea, right? That we treat corporations like human beings in a way, but we just take it for granted. But then on the other hand, I think there are a variety of reasons why especially conservative thinkers are skeptical of animal rights, or treating animals as legal persons. By the way, there's one person who has his camera on, and I'm not sure if he wants to have it on. So what was I going to say? Yes, so one thing probably has to do with Christianity, I suppose. So Christianity traditionally, the traditional Christian way of thinking is this strict dualism between human beings and others. So human beings have souls. Human beings are created in God's image, whereas other animals are not. So that would be one reason, another reason probably, I think especially certain legal thinkers are worried that this sort of post-World War II idea that all human beings have dignity and all human beings have equal dignity would be upset if we gave legal personhood to other animals as well. So there's a worry that it could somehow lead to the denigration of the rights of certain marginal groups, such as, well, for instance, mentally disabled individuals. And I think maybe a third reason is more generally this worry of a slippery slope. So you know, if we give rights to animals, then what's next? You know, or will they soon have the right to vote or something like that? So those are at least some reasons.
Thank you. Well, some scholars, such as Donaldson or Kinlika, believe that animals should have some rights similar to citizenship, right? And they should be represented in the system. Well, maybe the problem lies in admitting that people are animals also, and hence the boundaries between the species seem not so solid, right?
Yeah, that's right. I actually just attended a lecture by this Finnish sociologist Salla Tuomivaara on this very topic, because she's been interested in how, well, sociologists and social scientists have tried to sort of have approached the question of whether human beings are animals, basically. So some social scientists traditionally, such as, well, there was a famous Finnish 19th century sociologist, Edward Westermark, who thought that human beings are just a special kind of animal, but then many sociologists instead have wanted to keep this strict dividing line that human beings are not animals, or human beings are not mere animals. At least we are something more. We are somehow special, and I guess there's a lot at stake there, right? All kinds of moral issues, for instance. But by the way, the point about Donaldson and Kinlika is very interesting. So there's recently been what's called a political turn in animal ethics. So many animal ethicists are now thinking of how animals could be represented in all sorts of political proceedings, for instance.
Thank you. Is there anyone else with a question or a comment?
Yes, I do have one question.
Go ahead.
Okay. Yeah, so first of all, thank you very much for that super interesting presentation, which for me personally was not only interesting because, you know, the topic itself is, you know, close to my heart, but not really in the heart of my research interest, since I'm coming more from the, you know, corporate and financial law department, but still I'm, you know, researching sustainability aspects. So yeah, thank you very much for these insightful thoughts. But you know, my questions and the, you know, the point that interested me a lot is where my research on artificial intelligence intersects with your findings and, you know, your ideas on legal personhood in general. So this is exactly, you know, one of the main questions I'm currently researching. So the question whether, and if yes, how we can assign legal personhood to artificial intelligence algorithms. So though the problems and the questions, of course, are not the same, since the whole artificial intelligence discussion is missing the, you know, crucial dignity argument that's present within the animal personhood discussion. I think what is very interesting from what you said is that that perspective of not using this black and white approach, but of finding these different shades of gray that are in between. So I was especially looking at how, because I'm also researching like how social norms and human values correspond to these ideas of legal personhood when it comes to artificial intelligence. So the interesting thing is that if you ask people whether artificial intelligence, should be assigned, or if one should assign legal personhood to artificial intelligence, people, mainly say, oh my God, no, we don't want robots to take over the world, and that's just a crazy idea. But if you start from a more nuanced perspective and take out several rights from that, bundle of rights that would come with legal personhood, and if you ask, should it be possible for an algorithm, for example, to take several decisions while being appointed as a board member of a corporation, people say, yeah, I mean, that's okay if it's safe and if there are certain liability restrictions, that's okay. So I wanted to ask you if you maybe also confirm that the narrative about framing these issues when it comes to the social context of the acceptance of these potential changes, in the law, if you would see it different. I mean, if you would, also put a big emphasis on how the narrative of this is being framed. If you also see that a lot depends on how you just phrase these issues when it comes to how they are understood by society at large, but also how they are handled by potential regulators.
Thanks. That's a very multifaceted question and very good points, and your research sounds interesting. So in the book, I do actually discuss, there's a chapter on the legal personhood of AIs as well. And in the chapter, I distinguish sort of three contexts where you discuss AI legal personhood. So one is what I call like the ultimate value context. So that's basically the moral discussion. So this is like more like the sci-fi scenario that you have like AIs that become so much like human beings to develop sentience or something that we should protect them for their own sake. So that's one sort of context. But actually, I think most lawyers are not very interested in that. That's actually more like for philosophers and sci-fi novelists and so on. But what I think most lawyers are interested in is, first of all, the responsibility context, what I call the responsibility context. So could we hold AIs responsible in certain cases? And the other is what I call the commercial context. So could we use AIs as some kind of agents or even sort of independent actors in all sorts of commercial transactions and so on? And I would tend to agree with you that if you take legal personhood as this one big monolith, then the idea of giving AIs legal personhood is quite scary. But if you actually just focus on the individual incidents, it might actually be less scary in a way. Another thing is that the way I've sort of started approaching this is that you don't really, if you want to give AI some kind of a more limited status, you don't even need like according to the traditional theory, you sort of need some kind of declaration that the AI is now a legal person. But the way I approach it now is that you don't even need to like have this kind of declaration. You can just specify that the AI has this kind of legal status in a way. You don't need this sort of broader declaration at all. And that may also make it less scary potentially.
Okay, thanks a lot.
Thank you.
Okay, is there anyone else with a question or a comment?
May I have a short comment or and a question. I'm a specialist in Roman law, and that's why a short amendment to your speech. I mean, you are saying about the roots of this attitude, modern attitude in Roman law, and I feel you are right, but you are forgetting about the evolution of especially I feel that you should focus on antiquity and archaic times, also in Roman law, because when you have see some sources and informations concerning the position of animals among archaic societies or in prehistorical times, the situation was a little bit different in comparison to this strict division between animal and human. And it would be a another drop in your theory that we should come back to this more flexible vision of the position of animals. Because this position of animals is rooted in the tradition of more or less Christianity and the development of Christian ideas in European circle, cultural circle, I could say. So in this way, when you see some differences between animals among different nations or peoples in the past, you can find some another arguments for your conception and for your idea. I have in my mind the one example from Roman law, because when you see animals in Roman law, there's a strange independent position of dog, and in the case of dog, you have more something from prehistorical times, because dogs were treated in separate way or a little bit different in comparison to other animals. So it is the source of this more flexible vision of position of animals in among people in the past. And then there was a process of transformation animals into things, and then today we are starting the process of coming back to the normality, I could say. This your idea that the position should be flexible and should be treated from the point of view of interest is more or less correct, I think. And also this historical argument could be used to show that it was only a period of last 2000 or 3000 years maybe when the strict division was deeply rooted. Before, there was no strict division. And now we are coming back to the normal times, I could say. And also something else, we have a sign of this strange attitude toward animals. What wasn't mentioned by you, we are dividing animals into two groups. I mean, those who are domesticated and those who are pets. And also, according to modern legal regulations, you have some differences between pets and other animals. And those who are treated as cattle and those who are treated as our friends and our companions and so on. So that's why I'm for your ideas. And I feel that you are right from this point of view, that we are coming back to the more balanced vision of this reactions between humans and other animals, because I am for the idea that we are African ape, as a matter of fact, and that's why this division is only in our mentality and our feeling that we are better than our other animals. And something else, are you, and it was a small amendment, and one small question, because it wasn't mentioned in your presentation. I mean, do you know the ideas of Singer especially the idea concerning the expanding circle of compassion, because this idea is very interesting to show that we are developing our feelings toward, first of all, not only members of our family, members of our clan, then members of our nation, then all white people, then all humankind, and now we are expanding to the also to the animals. Do you feel that this idea would be correct or not? Thanks.
Yeah, thanks. I'm happy to hear that you agree with my sort of general ideas, but that there was a lot of points. As regards Singer, yeah, I think as a or this expanding circle of concern, I think in general that's correct. Of course, there are occasional sort of lapses when you go backwards, but in general, I think that's true. By the way, I'm not sure how many questions there are in the queue, but I would be interested in hearing like what kind of status dogs had in Roman law, because one example that might be similar is actually the status of dogs in like early common law, so like 17th, 18th century, because in the common law of that era, dogs were understood as having no property value at all, because you couldn't eat dogs or you didn't eat dogs. So they had no property value at all. So if you took the life of someone else's dog, you didn't have to pay any compensation at all to the owner. So is that something similar in the Roman law or something else?
There was similarity, but there was also distinction because all animals were treated in the way as you presented it. In the case of dogs, the rules regarding animals would be treated also, would be used also in the case of dogs. But there was a small distinction. I mean, the idea that dogs were a little bit different. I will send you the paper, which is focusing on this topic, and everything is in this paper, so it would be easier to understand. It wasn't the same as in the common law.
Right. Okay. Interesting. Yeah. And as regards to division into different kinds of animals, yeah, there are domesticated and animals and pets, and or companion animals, as some people like to say today. And I guess like the third major group would probably be wild animals. And then you can, of course, think of all sorts of smaller categories as well. So for instance, Donaldson and Kimlicka suggest the idea of liminal animals, so animals that are in a way integrated, are related to, have to do with the human society. So they're not living in the forest, but rather, for instance, all kinds of foxes, for instance, that have somewhat adjusted to human society. So they would be like a special case as well. But yeah, thank you for those comments and look forward to the paper.
Well, may I add something? These comments were interesting. Actually, some progressivists at the turn of the 20th century believed that it was the humanity that actually enable the humane treatment of animals by people, and the Christian paradigm was sort of a break between those ancient times and modernity that was supposed to engage in humanization of our relationship with animals. And about Singer, actually, he was not an animal rights theorist, right? He is utilitarian. So even though the theory of the circle is useful, it doesn't necessarily engage or in the animal rights theory.
So that depends partly on what you mean by rights. Again, because you could think that according to utilitarians, everyone has a single right, which is the right to be included in this sort of overall calculus, and to have their interests equally considered in that calculus. So that would be you could think of rights as being part of utilitarianism as well. So it partly has to do with how you define rights.
Yeah, Bentham mentioned animals, and he was very much against the natural rights, right? There is a question from Zuzanna Filipowicz on chat, and she would like to ask you what would be the criteria for granting animals any rights, and do we need to treat dogs and flies in the same manner?
Right. Yes. So that's a very crucial question, of course, and I think most people who work in animal ethics think that like the most important criterion is sentience or something very similar to sentience. So the idea that you can experience the world, you can have feelings, or you can experience pain, you can experience well-being or something like that. So that's like the fundamental thing. But then many people furthermore, as regards then flies, it's relatively unclear whether flies have any kind of feelings, so whether flies have sentience or insects in general. It's quite unclear. But then animal ethicists have relatively different opinions as regards like, should all sentient animals then be treated equally? So for instance, Singer, who was just mentioned, thinks that there are basically two groups of animals. So there are sentient animals, and then there are what Singer calls persons. And this is not necessarily, it doesn't have to do with legal personhood directly. But what Singer means by a person is an animal that has more or less like an understanding of itself and an understanding of its future. And such animals, well, it would probably include at least some chimpanzees and other apes and so on. So they would have the right to life, whereas other animals would not have the right to lives. They should still be, their interests should be like considered equally, but their life would not have any special value. And by the way, by right to life, I mean this. Well, I guess you should say that they would have the interest in being alive in the future, which should be considered in all sorts of when you consider like the consequences of your actions. So that would be one example. And then, for instance, Stephen Weiss and the Non-Human Rights Project. So they are mainly, though this is partly for strategic reasons, they are mostly interested in chimpanzees and elephants and such animals that they argue have a practical autonomy. So this kind of advanced capacity of like deciding about their own lives and so on, because I'm saying that it's strategic because I think their idea is that it's easier to argue for judges that these animals should be entitled to personal freedom than it would be with the case of, say, fish or something like that. But it's a very difficult question, and I don't have all the answers for you. It's a difficult question of ethics, definitely. So I've been involved in drafting the Finnish fundamental rights proposal, and we make well, first of all, we draw the line at sentience. So only sentient animals have fundamental rights, and whether an animal is sentient is a question of science, so it's not determined by law directly. And then we distinguish animals into two categories. So there's wild animals and animals that are dependent on human care, and they have somewhat different rights. So animals that are dependent on human care have more positive rights, so the right to nourishment and those kinds of things. I hope that at least partly answers your question, Zuzanna.
No. Yeah, it looks like it does. Well, Dr. Novak has a question as well.
Hello, my name is Maria Novak. Thank you very much, Visa, for your very interesting lecture. Unfortunately, I was not able to follow from the beginning, so I very much hope that I do not ask about something what you already said. So first, I wanted to quickly refer to the problem of animals in Roman law. So the division is not that simple, eatable and not eatable, because in Roman law, the value of animal is mostly not, its value as a meat, but rather as a workforce, labor force. So the most valuable ones are oxen. So and cattle, who are not only to be eaten, but to provide people with force work, because the most essential is grain, not meat. Meat is just, the rarity which you eat only sometimes, maybe on Sunday. I'm kidding, of course, with Sunday, but even less than once a week. So animals are not for food. So they are, but it's like, it's a side effect. And there is also the divide is more than one, but I will not bother you with this. It's quite boring, I think, for the audience. But my question is, it's like, let's underline from the beginning, I'm just a humble papyrologist. So it's maybe my understanding of legal personality is quite, wrong, old-fashioned, or just my education is too little, but I do not really buy this category, legal personality for animals, because as we understand legal personality, which is the concept built up on Roman law, it's not really Roman. Romans didn't recognize Roman legal personality itself. It's medieval concept, let's say. Yeah. So in this case, the essential is the ability to it's, your position in the market, in fact. And animals would never get it. And so maybe the entire concept is too old-fashioned for today. Maybe if we talk about animals and artificial intelligence, so maybe we should go a step further and say that legal personality is not enough. We need another concept. We need a new concept. What do you think about it? What could you say about this?
Right. So, yeah, that's an interesting point, definitely. So as regards like the animal status in the market, I wonder if you're partly, so this partly seems to have to do with the sort of how legal personhood theorizing originally was mostly a private law thing. So when you talked about legal person, it was mostly about private law. But it seems to me that that's not the case anymore today. So when people invoke legal personhood, they invoke it in all sorts of circumstances. It's spread much beyond private law, actually. So for instance, I'm not sure if there's a big debate about abortion in Poland, maybe there is, but in the United States, for instance, when they debate abortion, it's partly in terms of the legal personhood of the child. Or the fetus. So some states have, for instance, enacted what they call or fetal personhood amendments. And what they mean by that is that if you cause the death of a fetus, you're guilty of homicide, or if you cause the death of a pregnant woman, you're guilty of double homicide. So they're treating the fetus as a person in the criminal law context. And what my theory is trying to do, I'm not sure like at what point you could join in, but I'm trying to sort of encompass all of those different debates, not only the original private law notion where I think it originated, but rather like the more multifaceted debates of today. I wonder if that partly answers your question.
Yes, it does. But you see, the problem is that legal personality as such is rather private law, I think, at least historically. I'm sure not today, but historically. So if you can become an heir, then you have legal personality. This is the reason why for such a long time corporate bodies could not be recognized as a person in Roman law, for instance, and only later after Roman law. And we must agree that it would be difficult to provide animals with inheritances, to make them heirs. because what would they do with their inheritance? How would we, how would we recognize their free will about the stuff which they inherited? That's the problem. So.
Right. So this, on the other hand, depends or pertains partly to what I call the distinction between passive and active legal personhood. So I'm not sure if you could see the slide with what I call the incidents of legal personhood. Did you get the chance to see that? I could maybe just share my screen again briefly to show that. So according to my theory, there's both passive and active legal personhood. And active is what I think you're thinking of, which is like being able to dispose of your rights yourself and being held legally responsible. But the passive part, which I think even babies and animals could mostly have, refers to all sorts of things that don't actually require agency in the sense that you're thinking of. So you can, for instance, you're not property, you can own property, your body and life and personal integrity are protected, and so on. That you can suffer legal harms, meaning that if someone harms you, they are liable in tort law. That if someone commits a crime against you, you can be seen as a victim, and that you have standing in courts and so on. None of these actually require that you're an agent in the sense that you're describing. And actually, there are cases in common law in the United States, for instance, of pet trusts, meaning that because I mean, trust is how the common law traditionally works around the problem of children owning property, for instance. So instead of giving the property to children directly, you put it in a trust. And you can actually do that in the case of animals as well in some US states. So you can actually leave some inheritance to your pet dog, for instance. It's possible in certain US states. And of course, the dog itself doesn't take care of the administration then. Rather, the dog must have a representative who takes care of the administration.
Yeah, and it's not his or her their free will about it's it's that people decide what would be done with this inheritance, what would be done with this property.
Yeah, but it's for their benefit. Yeah, it's for their benefit.
For their benefit, but benefit understood by the third party, and that's problematic for me, But thank you very much. It was very interesting. I will still keep my reservations. But thank you. It was really fascinating.
Right. Yeah. Just to briefly conclude, I think you implicitly or explicitly are endorsing the will theory of rights. So rights have to do with control and choices and so on, rather than merely protected interests. I think that this is my diagnosis, which is fine. I mean, there are still many will theorists in today. So, but I'm not a will theorist myself, and I think many people are not. I mean, considering that we have, for instance, international treaties that give rights to children, for instance, it's quite difficult to be a pure will theorist today, I think. But yeah, thank you for the question.
Okay, and regarding antiquity, there is a difference between the law and culture and philosophy, as Seneca or Plutarch or Porphyry actually endorsed some animal welfare, right?
Yes, some of them did actually. But by the way, I should say that I'm very impressed by the knowledge of Roman law. I guess you must study a lot of Roman law at Polish law schools.
Actually, these were experts in Roman law that were speaking.
Okay, I see. Because Roman law is not a very big thing in Finland, because we're not actually a proper civil law country, where we have this like a sui generis Nordic legal tradition that's closer to the continental European tradition, but still. So we don't study a lot of Roman law here.
That would be a very welcome comment to our team, who actually engaged in some debate with a fellow of yours from Helsinki University, but I don't remember the details.
Oh, right, maybe Caio story or something.
Okay, is there another comment or a question? If not, maybe I can ask another question. You have mentioned Christianity, and my question is whether it is necessarily contradictory with the animal rights theory, as there are theorists that endorse the so-called animal theology, right? Like Andrew Leesney, for example.
Yeah, there are some, and there's a research center at Oxford called the Oxford Center for Animal Ethics, which is actually quite strongly affiliated with the sort of animal-friendly theologians. Yeah, and I think it's, well, I'm not an expert on that, but as far as I know, that's recently gaining more and more traction. So like theologians and scholars of Christianity have become increasingly interested in how whether you could, in the sort of Christian context, somewhat reduce the sort of hierarchy between humans and other animals. But I think most still would agree that you can't sort of completely remove it from Christianity, that would be difficult. And of course, like the traditional, what some people call indirect animal ethics. So the idea that animals should be treated well, but not for their own sake, but rather for our sakes, because so that has like Christian roots in a way. So it's in order to not become sort of insensitive brutes toward each other, that we should be treating animals well. So that definitely does have Christian roots as well.
Well, it is my idea that if conservatives as well as socialists or liberals think hard enough on their ideology, they will find good reasons to care about the environment or animals in it, right?
A small amendment concerning Christianity. According to some views, the idea that animals weren't used in the cult, I mean, as a part of religious belief, they weren't used in it, was a step to treat them as things. This idea is presented by some scholars. I don't want to exaggerate that they are right, but we have to also take into consideration this point of view, that Christianity was progress, but progress in the field of human rights or pro-human rights. But on the other hand, the removal of animals from religion at all, they weren't used in cult, they weren't treated as the members of, or parts of them were used in the cult, was the reason that they were treated more close to the Greek ideas of this division, that there are some beings with souls and those who are not equipped with souls, and that's why we can treat them with brutality and so on. So this point of view is maybe exaggeration, but we should also remember that not everything connected with Christianity was correct from the point of view of animals.
So just, I sort of didn't get the very first part. So did it have to do with animals and like ritual sacrifices, or what was the very first part?
Yes. I mean, ritual sacrifices were the way animals were necessary. Then animals were unnecessary, and in this way it was a step to treat them as things.
Right, because they became in a way irrelevant for religion in a sense, for like religious practices. Yeah, okay, that's an interesting idea, definitely.
Anyone else? Okay, if not, then perhaps it is the time to end our meeting. So let me thank again Dr. Kurki for his excellent lecture. and of course the audience for being with us. I am certain that we will pursue the method further and in a time invite someone else, or maybe Dr. Kurki, if he would be so kind to join us again to speak on the matter. So thanks and good luck in Cyberpunk, as I believe you have referred to the game at the beginning. Thank you.
Yes, thanks so much for the invitation. And if I don't see you again at the seminar next week, which I'm giving, it was Pavel Banash who invited me to another seminar. If I don't see you there, I wish you all a very pleasant Christmas, and those of you who will be entering the world of cyberpunk on Thursday, have fun.
And to you too.
Yes.
Bye.
All right. Thank you. Bye-bye.
Thank you very much, and bye-bye.
Yes. Thanks.